Hi, my name is Michael Burgis. I'm the managing attorney of MB&A. I'm a certified legal specialist in California workers' compensation, and I'm a trial attorney. I wanted to briefly make a video to discuss what is becoming a more frequent question, and that is, can an injured worker in California obtain a service dog through their workers' comp claim? The short answer is yes. It's a bit of a difficult road to successfully obtain, but the answer is yes. In California workers' compensation, an injured worker is entitled to anything that is reasonably medically necessary to cure and relieve the effects of their industrial injury. Now, ultimately, the Labor Code 4610.5A2, lays out what is the hierarchy for determining medical necessity. In essence, the first is something called MTUS, or Medical Treatment Utilization Schedule. If an injured worker can show that the service dog is needed and is consistent with those guidelines, then they should be legally entitled to it. If MTUS or another guideline doesn't specifically address the service dog or the medical necessity in this particular case or fact pattern, then the physician can do what's called a peer review of scientific or medical-based evidence. They can look towards nationally recognized professional standards. They can look for an expert opinion. They can look for generally accepted standards in medical practices. And then they can discuss that treatment are likely to benefit the patient and explain the sort of how and why. But there's a hierarchy to determine what is quote-unquote reasonably medically necessary. And the first thing you look at is the respective guideline. In California, it's incorporated what's called Medical Treatment Utilization Schedule. So ultimately, if you have an injury and that injury necessitates the use of a service animal or emotional support animal, that can be obtained through California's workers' compensation, so long as the physician can break down and explain why it's quote-unquote reasonably medically necessary. There's a case that just came out that discussed that for a injured worker who had significant industrial injuries, and including a diagnosis of narcolepsy, that emotional support animal, or rather that was a service animal that was needed because of the narcolepsy, and it was awarded. Ultimately, if the injured worker needed an emotional support animal because of depression or anxiety, as long as we can justify and explain why it's reasonably medically necessary, the injured worker is legally entitled to it. If you have any questions or concerns, my office is standing by. Feel free to give us a call. We have the answers.